Hi, my name is Antonio Gastelum and I'm a partner at MEG International Counsel with offices in San Diego and Houston. Today we continue with the series of frequent asked questions that we get. And today's question is, can I involve my outside advisors when planning my estate or business plans? The answer when we come back. Join us. Today's questions, can I involve my outside advisors when planning my estate or business plans? The short answer is yes, of course. And the reason people ask these questions is because we found that in many cases when they want to involve their own advisors that may be able to contribute, the big law firms and the national law firms tend to want to keep all the business to themselves, and they tend to say, no, we can fix it or we can work. We don't need anybody outside ourselves or our firm. And we found that usually when the client is able to bring their own advisors, their accountants, or their local attorneys, their attorneys in their country of origin, we're able to come up with better plans and we have better outcomes for the clients. We're here at MEG International Counsel. We're widely recognized as a firm that teams up with our clients and their advisors. Nevertheless, when those outside advisors do not have the experience demanded by the matter or do not have the knowledge to achieve the desired objective, it may be necessary to hire other professionals or experts, even if they are not part of our firm. Notwithstanding this, it's important to maintain the confidentiality and the attorney-client privilege protections afforded by U.S. law that don't necessarily happen when we use the client's non-attorney external advisors or the attorneys in their country of origin. As an example of these risks, the OECD, or the Organization for the Economic Cooperation and Development, has issued the commonly referred rules of disclosure for advisors. Although the official name is Rules for the Mandatory Disclosure to Avoid Regulate Plans that Avoid CRS and Obscure Foreign Structures. Let me repeat that. Rules for the Mandatory Disclosure to Regulate Plans that Avoid CRS and Obscure or Offshore Foreign Structures. Basically, these regulations require the reporting of their clients by their attorneys to the appropriate tax authority and of any plans implemented by those advisors or attorneys to avoid reporting under CRS, whether they are attorneys, accountants, financial advisors, banks, or any other service provider. So basically, if you're not in the U.S. or your country is not known for feverishly defending and rigorously maintaining the attorney-client privilege between attorneys and their clients, and to keep in what's called the professional secret or the confidentiality duty that advisors have, especially attorneys, with their clients. The OECD came out with these rules, and a lot of countries have implemented, countries that are members of the OECD, that require now, like the case in Mexico, where now they require attorneys, CPAs, if any of them create a plan for a client that allows them to avoid reporting under CRS rules, that they did this plan or that they have to pay taxes. I'm not saying avoiding taxes, avoiding just the reporting. Then those advisors, those clients need to pretty much rat on their clients. And on the other hand, in the U.S., which the attorney-client privilege is always protected, we don't have to do that. Although the OECD says that if your country protects the attorney-client privilege, then it's on you as a client to report yourself, which is absurd. But in a press release in March 2018, the OECD announced that by issuing these rules of disclosure for advisors, they targeted the advisors and their clients because, as they said at the time, and I quote, "The time is up for these tax evaders and their advisors who still want to play with the rules and continue hiding their assets overseas or offshore." After you hear this or read it, it appears that those that control the OECD have lost their minds. However, when we analyzed the published question and answer document that defined how these new rules were to be implemented, we could only confirm that they were actually close to losing their minds, since the defining document indicated that those rules will not require intermediaries to disclose information that is subject to the rules of professional secrecy, which I was just telling you about, which are generally reserved for lawyers and sometimes the clergy. And what this means is that if your country of residence is a member of the OECD for CRS purposes, but does not have laws or case law, as well as a verifiable history, as I was explaining before, of having truly enforced the attorney-client privilege and the confidentiality of client information, the only alternative, if you want to preserve your privacy and your personal or family's physical integrity, either under CRS or FATCA, is to consult an attorney in the United States, because our country has mandatory non-disclosure and confidentiality laws and also is not a CRS signatory. Unfortunately, hiring advisors, accountants, economists, promoters, brokers, banks, brokerage houses, or any other service provider which are not attorneys or whose services or relationships, even in the United States, are not protected by the duty of confidentiality or the attorney-client privilege, could end up being quite expensive for you. Despite this situation, the OECD has extended its criminalization attempts to potential victims of extortion and kidnappings who seek only protection and privacy by forcing the clients to report themselves for lack of such confidentiality cover. So this is basically what we were telling you. A lot of the reasons many foreign clients plan in the United States is to keep their privacy and for safety reasons, because whatever information the U.S. may automatically exchange with them may not be important or may not be revealing, or it's not in violation of any law. Sometimes that information gets leaked out of the government and the federal agencies and the bureaucracy, which allows the bad players in the country to extort and to attempt against your physical integrity and your physical safety. So that's why a lot of people use the United States as a safety valve. And while our professional, personal, and unwavering position is to not condone or approve tax evasion or money laundering, this recent proposal by the OECD is truly insane. We cannot call it anything differently. Therefore, it's necessary that each inquiry that is made to advisors who are not attorneys are instead done under the protection of the duty of confidentiality and the attorney-client privilege, as I've just described. So that is why sometimes, in our case, it's always to consult with a U.S. attorney, even if you're working through or with your a personal advisor or your CPA or your attorney in your home country regarding a U.S.-based plan or strategy, or even a foreign-based strategy. It's important to consult the U.S. attorney, so at least you can use the attorney-client privilege covered given by the U.S. law and the U.S. rules of confidentiality that will protect you, and not only you, but also your advisor and your CPA. So that's why it's important to now, unfortunately, your only choice is to use the cover provided by a U.S. attorney-client privilege. Okay? I hope you enjoyed this video. If you have any questions or concerns, please give us a call and schedule an appointment so we can discuss your questions further. I hope you enjoyed this, and thank you for watching. Bye now.